Hello everybody and welcome back to the English Law channel. So I'm carrying on with proprietary estoppel because there are so many cases on this one to look at. So guest and guest is an important case on this issue. It's a case from 2020 and this is about how equity can arise for the claimant through proprietary estoppel, how this is remedied. So there is a large number of cases about this, and there's a lot of scholarly writing on this one, what the court's aim is and what it ought to be when it's exercising its rather wide degree of discretion on this one when they're doing justice, but trying not to go too far, not being overly generous to the claimant. So in briefer summary, the court's award is meant to fulfill the expectation interest without being disproportionate, but some people say it should only provide compensation for the detriment experienced by the claimant. So it should be reliance-based. So Lord Justice Lewison in Davis and Davis 2016 said you don't need to resolve it in a simplistic way. It doesn't have to be either or. Now some people say it would be better if you could do that. Some people say it's impossible to do that. But it doesn't have to be tidy. It doesn't have to be binary. So there have been a few decisions in the last few years, particularly after Jennings and Rice, which have shown a growing tendency to plump for this a balanced approach to try and blend expectation and reliance-based together, have proportionality. Guest is a case in point. So Guest left school in 1982. He's the claimant, Andrew Guest. He spent over 3 decades working on his family's farm. His parents, David and Josephine, owned it. So over several years, the parents promised him that he would inherit at least part of the farm, a large part of it. So Andrew acted to his detriment because he worked at the farm for tiny wages. Remember, there was no minimum wage back then. He could have found more remunerative work elsewhere. But he had a terrible falling out with his parents in 2015. Andrew stopped working on the farm. In 2018, his parents drew up a new will, and as testators, they were giving him nothing, giving it all to his siblings. So Andrew was successful in making out the necessaries of a claim and proprietary estoppel. So the issue that confronted the court was what he should be given. So Judge Russon, QC, said that promises to Andrew were vague, and this wouldn't warrant an award of what he had been promised. Further, bear in mind that he was estranged from his parents. It wouldn't be apt to give him much, so therefore they had to split him off for his parents and give him an amount of money. So David guessed he launched an appeal, and he claimed that what Andrew had been given should be based on the increase of the value for the farm that was down to Andrew, rather than what had been promised. David's the father, by the way. The Court of Appeal said the promise that Andrew would inherit a large enough interest in the farm to allow him to set up a farm of his own in future had been unequivocal. So Lord Justice Floyd said Lewison was correct. That's Lord Justice Lewison, because he had this little ratchet approach in Davis, and that was following Jennings. And he said, the clearer the expectation, the greater the detriment, the longer the passage of time through which the expectation was reasonably held, the greater the weight that should be given to that expectation. So Judge Russon gave an amount of money to him. It was a 50% of the value of the farming business, 40% value of the land, and this was found to be apt, bearing in mind what Andrew had expected to get and the need to split off his property from his parents because there was such a fractious relationship. The Court of Appeal's judgment has not settled this for all time. The theoretical basis of this remedial discretion is still hotly disputed, but it shows us just how adaptable the law can be, particularly in unusual cases, estoppel claims, where all the protagonists are still with us. It's not always inter vivos. So in More and More 2018, the court held you have to find a remedy which bears in mind the need to have a clean break between the parties when they're very disharmonious relations. Another case that you should examine about remedial discretion is Haberfield and Haberfield 2019. Here, Lord Justice Lewison said you have to recognise the claimant's remedy should be closer to the expectation where the detriment comes close to performing a bargain. So the Land Registration Act 2002 and gives us an equity by estoppel, and it says it has effect from the time the equity arises as an interest capable of binding successors and title. So it was approved that an uncrystallized estoppel equity can be binding upon someone who receives the property, the transferee, if it's protected as needed under the usual rules of registered or unregistered land. In registered title land, it can be protected by putting it on the register or with actual occupation, so it can be an overriding disposition. However, if a court's given a remedy, then whether the transferee is bound by it or not is contingent on the sort of remedy that's been awarded. For instance, if the remedy is a freehold or an easement, then yes, it is binding upon the transferee. However, if it's a license or it's pecuniary in nature, then it's not binding on the transferee. So that's enough. I know it's quite a difficult issue, and there's so many cases on it, but to go through somewhat contradictory decisions over the decades, and it's probably the most rapidly developing area of the law of property. That's enough from me. Toodaloo.